That is why Lordship raising stock and asked the registry to verify the paper book also. And last occasion when it was come up Lordship, then also we made a submission to submit the paperwork within a week. But Lordship, when we inquired the matter, then the paper book section stated that there are lots of difficulties also receiving the typing, so we cannot give it directly. So you make a mention before the court. If they do this, then it will be okay in our court, Lordship. Earlier we prepared a paper book. That's the problem. Though it is in the hearing,
Okay.
mention for orders.
Please make a mention at 2 o'clock. In the meantime, we'll see it. We'll get it verified and then we'll, because we are not following you. At 2 o'clock, let me.
There's a mistake in the typing, Lordship, because it was by us. That's the thing that was raised by the opposite party. That is why hearing stopped and pass a direction by this court to verify by the registry and thereafter placed before the court.
Okay.
So, we contacted the paper book section, Lordship. They verified, but they did not provide us what mistake is there. That is why, Lordship, our humble.
Okay, we'll try to understand. We'll call this section people at 2 o'clock. Please be here.
For adjournment, Your Lordship, in item 14 of the hearing list.
Fourteen is a 2016 matter. 16 matter, we are not adjourning.
It's out of session.
No, but still we'll see when the matter is called, then we'll see. 2016 matter, we are not adjourning. Please be here when the matter is called. We'll examine and then we'll see. Yes. One to five, all jail appeal. 383 with 374 appeal. Appeal is admitted for hearing. Call for the records. We are inclined to appoint. From this, take 1, 2, 3, 4. Seriously, 1 to 5. So and so as amicus curiae in the matter. So in the meanwhile, the AOG criminal appeal section shall inform the learned amicus curiae about their appointment by the court. List after 4 weeks awaiting receipt of LCR.
May I submit, Lordship? One of the Alex Tusker is present, Lordship, is one of the amicus curiae.
In item, okay, in item 1, make a mistake, Mr. In others, you give serially from that list. List on so and so. And just check if there is respondent number 2, that means POCSO matters, then notice is to be issued on the informant. Registry shall prepare the notice and hand it over to the learned APP for service on the respondent 2 by through the jurisdiction police station. Protect the presence of Ms. SH. Bara and AVP. Okay. 6, 1 to 5 is over. Yes, item 6. Yes,
May I please your lordship?
yes.
There is an application under, appeal for conviction. As under section 302. your lordship.
302. Okay, your name?
Kilo,
D
Mumin. Mumin.
MOMIN.
MOMIF.
N. Moment.
Momin. Okay, Momin. Counsel for the appellant, same order. 302. But since you have made respondent to a party, we'll ask you to take steps. The appellant shall take steps within 2 days for service of notice on respondent 2 by registered post with AD. Counsel for the appellant is permitted to collect the postal receipt number, fact report, list on so-and-so, awaiting service report and LCR. Yes. Yes, item 7.
What's wrong with my lord? 20 years punishment is.
Okay, it has come for the first time.
My lord.
Come for the first time. This has come for the
Yes.
first time. Okay. Mr. DCC, Pukan, counsel for the appellant. Here notice on respondent 2. By registered post will AD as well as per usual process. The registry shall process the shall hand over the process to the learned APP for onward transmission to respondent number 2 through the jurisdictional police station. Okay, what is the second? I for bail.
Bail and.
Okay, bail shall be considered on receipt of LCR. Okay.
Apply.
Give a fixed date on all these cases where service report is there. Give a fixed date after 6 weeks. You do it in the meantime. We will give you a date for taking steps.
Item 8.
Yes, item 8. Okay.
Speaker actually disclosing.
Lordship, assets and liability. Lordship.
Assets and
We have received the instruction day before yesterday, Lordship. Lordship, 2 weeks time may be granted to find out affidavit in opposition, Lordship.
Okay.
Will file within 2 weeks.
Okay. Both of you filed within 2 weeks. Okay. Mr. H. Chaudhary, counsel for the appellant, as well as Mr.
And K. Sharma, Lordship.
N.K. Sharma, counsel for the respondent. So both sides pray for and praise for and grant are granted 2 weeks time to file affidavit in terms of order dated 17/10/2023. Was released after 2 weeks.
Deep level, Lordship.
This is still in condonation stage. No, delay has been condoned. Okay, it's condoned. Okay. It's a 22 appeal. 22 appeal. Give a date after 2 weeks. They're giving a fixed date after 2 weeks. They'll give you after some time.
Deep level, Lordship.
Item 9.
Yeah.
Yes.
But. Entire for consideration of bail and the DUP petitioner and bail.
For bail.
But what in this case,
Just a moment. But in this case, we are not inclined to grant you bail. The victim is a 5-year-old girl.
The Lordship kindly appreciate one thing, there are two occurrences. As per the Azahar, it is the case of the informant that his daughter was raped on 28/6/2014. And another incident occurred on 30/6/2014 Lordship. He lost the Azahar. What he stated in the Azahar, Lordship kindly have a look at that.
No, whatever is there, but we find that there's evidence to that
Lordship,
effect.
whether his Lordship evidence is believable, that is Lordship.
Then we'll have to examine. We can, since the paper book is ready, we'll take it up for hearing, but
Lordship,
interim bail,
may
we are
I-
not in time.
may he Lordship humbly submitted, Lordship kindly have a look. It is the case of the informant that while his wife went to the hospital and in the taking the advantage of his daughter in the house alone, accused person entered. This person was not even supported by his wife. And both the side stated the same story, Lordship. PW1 and PW8, Lordship, who is the father of the second victim, Lordship. The story narrated in both the cases are same. Lordship, that aspect kindly have a may I read the Lordship?
Just a moment, just a moment.
Lordship, PW9 is the mother of the second victim, and PW1 is the father of the victim number 1. Lordship. And both the PW1 and the 9 stated the same story, which is not even supported by the one of the witness, that is the wife of the PW1, that is the mother of the Lordship, at least victim number 1, that is the Lordship Pooja Das. That is also not even supported by PW2. He stated that he was in the house of his landlady. There is a Vipodnashini Puja. But PW1 stated that his wife went to the hospital. PW9 also stated his wife went in the hospital, and it is the occurrence of 28/6/2014 and 30/6/2014. So, Lordship, is it a believable story? Lordship, may I have a look at the Azahar, Lordship, at first, Lordship?
Who is PW2?
PW2, Lordship, is the mother of the Pooja Das. That is the victim number 1.
And who is PW1?
One is the father of the victim.
Public CGM. First of all, the notice is made returnable on so and so, same 15/3/2020. List on the said date, awaiting service report. And the top you also write, the LCR is called for is received. First of the registry shall in the meanwhile prepare the paper book. And I also write the same order, steps for service of notice on respondent to. This interrogatory application shall be considered on receipt of service report on respondent to. Same 15/3. This is item 16/17.
Supply item 16 with 17.
17, madam. Okay, madam, in this case, I has been, the LCR has been received, madam. Paper will be have to prepare.
The registry is wanting 2 weeks more time for the for this. Okay. Both sides are represented. In terms of office note dated 25/1/2024, whereby the registry is seeking 2 weeks more time to prepare paperwork. The matter stands adjourned today. Give a date after 3 weeks. We are making it 4 weeks. Give a date after 4 weeks. List 163, looking receipt of paper book. His volume is they are wanting more time. It's gone to translation section. Every translation could not be made.
Item 18.
Yes.
No, it's fine.
Yes.
This matter was filed during the vacation pertaining to an appeal against the order passed by the special court post to Rima Korean. And we filed an application while filing the IA for listing it for the principal bench at Guwahati. And we have received an SMS from the registrar that it is under objection. So somehow it get listed in your lawsuit. We are before your lawsuit.
No, because if it is even if it is filed under vacation, you have to mention it and then the registry permits that listing in the vacation.
Registrar permitted and informed us in for an SMS.
Oh, okay, okay. Just a moment. There is some note. You are Mr. Z Khalid. Mr. Khalid, you see, we understand during the, if it is filed during the vacation, it can be filed here, but there has to be a note to that effect. Once it is not there, we on the administrative side, only the Chief Justice can tell it. What you can do is that
When filing application for the, while filing this, I have filed a application for the Honorable Chief Justice for listing the matter before the principal bench.
okay.
And it was under objection, and we have
Oh,
received, we have received an SMS, so we are in the presumption that matter has become infructuous, so we are.
Oh, acha. Okay. I'm sorry, I did not get it. Oh, okay. So we send it back to the Diwapur? Sorry, the Kohima? That would suffice?
Yes.
Okay. Her Mr. Z Khalid, learned counsel for the appellant. First of all, it is submitted that this criminal appeal was filed before the principal seat as Kohima permanent bench was on vacation. Next para. He has also submitted that he had made a request before the registry to get the administrative approval for filing from Honorable the Chief Justice, but he has received a SMS message from the registry to the effect that the filing was under objection. Accordingly, it is submitted that he was not aware that the matter would be listed before this principal seat. Next para. Be that as it may, as the administrative approval of Honorable the Chief Justice is not attached to this appeal, comma, having noted that this appeal was filed on 10/1/2024, during which time the Kohima permanent bench was on vacation, comma, we are inclined to direct the registry to transmit this appeal along with connected interlocutory applications to the Kohima permanent bench. Full stop. I'm gonna just, so that as we are accordingly we are inclined to direct the registries to have the matter listed before the to see that the matter is listed before the Kohima permanent bench on after 2 weeks. Give a date when you can appear before that.
February last week, your lordship.
February last week. Okay. 26th February. Okay. Just check 26th February in Kohima. It should not be a holiday. Twenty-sixth February is not a holiday. Okay, it's working day. Okay, list on 26/2/2024. First of the learned counsel for the appellant shall appear before the Kohima permanent bench without awaiting any notice for appearance on this said date. Next, let this order be brought to the notice of the AOJ Criminal Appeal Section, so to enable the registry to transmit the records to Kohima permanent bench. Okay. Yes, item 14.
But this matter has been fixed for final hearing, but, as my senior, he has to leave for Delhi, for some urgent factor.
Just a moment, let me examine the records. Are you aware of the developments with regard to the case diaries? You're aware of it? No.
Very good. It is. Yeah, this is-
Ayush Chaudhary, I'm sorry. Mr. Ayush Chaudhary for the appellate number 4 and 5. You are for 1, 2, 3.
3, 6, 7, 10, 11, 12, 13, 15, 16.
Be slow, repeat again.
1, 2, 3, 6, 7, 10, 11, 12, 13, 14, 15, 16.
And you are appearing for 4 and 5. What about others? There are a few left out. Oh, okay. Oh, okay. None appears on call for the other appellants. Next paragraph. It is observed from the previous orders of the court that certain auxiliary issues had cropped up in course of hearing. Full stop. We are inclined to observe that all the auxiliary issues shall be taken up in course of final hearing of this appeal. Mm. Have you noticed that just say the learned counsel for the right name, Ms. So had prayed for an adjournment. So have you noticed that this appeal is of the year 2016, matter is reluctantly adjourned. It is made clear that the matter would not be adjourned on the next date of hearing. List on the date of hearing. 2 weeks. Thirteen to 2024. Yes. Since there are just a minute. Next para. Having noticed that 3 sets of learned counsel are appearing for the appellants, also the learned counsel for appellants shall also file their written note of argument on the next date of hearing. Judgment for it.
Item 15 for hearing.
There's a small issue I'd like to point out. This is a POXO appeal, my lord, and when the appeal was admitted, at that time, my lord, in 2022, notice.
Service report of service report on respondent 2. Pardon me. Oh, acha, I also notice. In I also separate notice on authority application. Okay.
Supply item 19 for hearing.
Mhm. Oh, this has gone to Supreme Court. Oh, this is it. What we'll do is, the LCR is available here. Now, on that date, we call for the LCR. The LCR is here. 3 LCRs are available. One is Sessions Case number 69, N of 2011, GR case 975 of 2008, file A and B, as well as file C and D. So therefore, the LCR is available here. Now, we take note of the order of the Supreme Court. That original records have been received from High Court and Trial Court. So what we'll do is that the original records will directly register to send it to the Supreme Court of India. And a scanned copy of, a photocopy of the records will be sent back to the trial court for this, for hearing on sentence. Hmm? Write the order. We may, what you call, have to correct it once we after we dictate it. Let's see. None appears in call for the appellant. However, Mr. F.K.R. Ahmed and counsel for the private respondent number 2 to 7 and Miss 2 to 10 and Miss S.H. Bora, learned APP for appearing for respondent 1 are present. Next para. The attention of this court is brought to the order dated 6/7/2023 and 9/8/2023 passed by the Supreme Court of India, passed by the registry of the, passed by the registrar of Supreme Court of India in connection with criminal appeal number within bracket S, bracket close, full stop, 583 of 2023. Full stop. In the order dated 9/8/2023 of the proceedings, it has been recorded that the original records have been received from the High Court and Trial Court. Full stop. Next, it may be mentioned that the notice of the court is also brought to the fact that during the pendency of this appeal, the appellant number, sorry, the respondent number 9, Mohammad Mukhtar Uddin, Mukteruddin, had approached the Supreme Court of India by filing criminal appeal number within bracket S 583 of 2023. Insofar as the order of conviction is concerned. Next para. We have also noticed that this court by judgment and order dated 23/11/2021 passed in criminal appeal number 144 of 2014 had convicted the appellant numbers eight, 5, 7, 9, and 10, namely, you just write these names from the record. I'll just indicate the names, but you type it correctly. Baharuddin, Johirul Islam, Joyrul Islam, alias so-and-so, Johirul Islam, Muhammad Islamuddin, Muhammad Mukhtar Uddin, and Mohammad Suraj Ali, who were directed to surrender before the Court of Learned Additional Sessions Judge Hojai by providing that on their appearance before the court, they shall be taken into custody, and thereafter the Learned Additional Session Judge will record their statements and evidence for the purpose of sentence hearing by this court. It was also provided that in the event the accused persons of the convicts fail to appear before the learned trial court, the said court was at liberty to issue warrant of arrest to procure their attendance. It was also provided that the report of the learned additional session judge, Hojai, will be placed before this court for the purpose of awarding appropriate sentence. It may be mentioned that the said appellants were held to be guilty for commission of offense under section 147/148/302/149 IPC. Thus, the acquittal or the acquittal of respondent numbers or the remaining respondents were upheld. The remaining respondent numbers after this, whoever remains, you just say like this: respondent numbers 2, 3, 4, 6. Died in the meantime? Who died in the meantime?
Suraj Ali.
Suraj Ali.
And
Number 10.
one more lady, but I forgot her name.
Aflatun Nessa. She expired. Next para. The learned counsel for the private respondents has submitted that as per instructions received by him, the respondent number 6, namely respondent number 6 and 10, namely Musammat MUSTT, full stop, Alfatun ALFATUN, Nessa NESSA, next word, and Muhammad Suraj SURAJ Ali have expired. You received instructions, no?
Followed, I have not received none. During the mile of pendency of the appeal, but before hearing on 23/12 mile, I did my addition there. So far as the Alpha Nessa, say that I received. As far as Suraj Ali is concerned, my lord, that I received from the after of the records, my report set. After going through the records, my lord, and I have seen that, my lord, last occasion, my lord, on the Honorable Court observed that was Suraj Ali is also expired.
Okay. It appears from in the said regard, we may refer to order dated 20 3/11/2023 passed by this court, wherein the court had referred to a report received regarding the death of respondent number 10, namely Mohammad Suraj Ali. Full stop. However, the learned counsel for the private respondents have submitted that he has not yet received any document regarding death of respondent number 6. Next paragraph. By order dated 23/1/2024, we had direct the criminal appeal section to verify the record and send the records back to the court of the next date of listing. Full stop. Accordingly, the registry has put up a note, has put up two notes dated 24/1/2024 and another note of 25/1/2024 indicating that the original case records were called for from the additional district and session judge Shankardev Nagar Hojai, and that a report has also been received from the said learned court, and moreover, LCR LCR containing 5 files in connection with sessions case number 69 within bracket N of 2011 was received from the learned trial court. Next paragraph. We have also seen the report dated 20 January 2024 submitted by the learned district and sessions judge Hojai. So the it is Hojai. Report. This is green flag, report 1. You will quote this. So it is appropriate that the said report be quoted below. Next para. Having noted that that in the order dated 6/7/2023 passed by the Registrar, Supreme Court of India, there is a reference to the original records being received from this court. No, sorry, 9/8/2023, from this court as well as from the learned trial court. We take. We are inclined to direct the registry to send the original trial court record to the Supreme Court of India. However, photocopies thereof be retained, be made and sent to the learned.
Key reference of performance.
Right. First of all, while the registry while sending the original records, original LCR, shall enclose therewith the copy of hearing before referred order dated 9/8/2023 passed by the Registrar, Supreme Court of India, as well as a copy of this order, so that the LCR may be tagged in the appropriate, tagged with the appropriate record. Next para, insofar as the photocopy of the LCR is concerned, let the photocopied LCR be sent back to the Court of Learned Additional Sessions Judge Hojai Shankardev Nagar for compliance of directions contained in the judgment and order dated 23/12/2021 passed by this court in criminal appeal number 144 of 2014.
With report again, photocopy in
Just make necessary correction there. We have said make a photocopy. You say make 2 sets of photocopies. Huh? Then here you write in the last part, 1 set will be sent back. Now next para will be the other second set of photocopies shall be retained in the retained with the record. Next para, the learned additional sessions judge Hojai Shankardev Nagar shall inform the
How it is session judge?
now it is sessions, not additional. Okay. Additional sessions, Hojai, to submit its report and obligor status of the proceedings to this court for being placed before this to this court. Next para, list on after 4 weeks give a date. Make it 5 weeks. After 5 weeks give a date.
11/3.
Okay. A lot of problem with this record.
Yes.
Now the original record is here. Supreme Court order says that we have received the original records, and what records they have received? Or if they have received the original record, what is the record which is available here? Okay. Yes, Mr. Goswami. For
Have a matter before your lordship.
in single bench. Oh, okay. Okay.
Division or end?
One matter left in the division bench. Very good.
Daily list or item two.
We'll take a break and come back again. In this matter, Ms. Nagis is not there. Ms. S.K. Nargis, learned counsel for the appellant, had submitted that the the paper book was prepared by the appellant's side. And when the records were verified by the registry, certain objections were made. So it was submitted that when she had met the concerned official, they did not provide anything to her in writing. And accordingly, it is submitted that the paper book could not be rectified. Next paragraph. It is observed from the office note dated 29/11/2023 that the AOJ paper book section has noted the following discrepancies. Colon dash and then next subparagraph. A. 6 accused were examined under section 313 CRPC, and it was observed that 3-4 questions are missing in each set of questions that were asked to the accused in the typed copy produced by the learned counsel in the paper book. Number 2, it was also number 2 is in most of the exhibited documents, there are some typing errors that must be rectified. Full stop. Next paragraph.
My lord, we can do one thing, Lordship. If they will prepare and cost we will pay,
Okay.
that will be better for us.
Okay. Next paragraph. Next paragraph. The at this juncture, this is a regular paragraph, huh? Not subparagraph. At this juncture, the learned counsel for the appellant has submitted that she is ready and willing to bear the cost of the preparation of paper book. Next, accordingly, the registry shall prepare a paper book and shall indicate the cost of preparation to the learned counsel for the appellant, just to enable it to deposit the cost. Next one. List after 4 weeks awaiting preparation of paper book.
It's, I think it's prepared, Lordship, only,
It's okay, you see, since it is
We-
voluminous, we
It's
can't
already
presume.
prepared, Lordship. That is why it will not take much time.
We are only giving 4 weeks because we don't know. You see, we don't know today. Because since the records are voluminous, we are giving them 4 weeks time. They will prepare it and send it.
Instead of 4 weeks, can it be 2 weeks, Lordship?
So they will not be able to do it. Because I have, you see, I have visited those sections. The difficulty now right now is that the most of the translators in the with the registry is engaged in a voluminous work, which is translation of orders in Assamese, and that is a priority because of some issues which is taken up by the by our administration. Therefore, we are not disturbing that, and therefore we can't give a very small short direction. The registry has engaged those persons by orders of the Honorable Chief Justice. So therefore, we can't expedite it
After 4 weeks, Lordship, it will come again in orders for.
in orders for law.
we have completed almost the matter partly earlier occasion lordship, but during that time, the learned opposite council lordship, they never raised any point to that regard because paper
No,
was
you see-
prepared in the year 2019 lordship.
No, Mr. Nagesh, you see, the difficulty is that people don't compare it. Normally, when you give a paper book, nobody will start comparing the paper book with the trial court record. It's normally not done. So it is,
All are in English. Original record is that.
it's okay.
And in some lordship, one set up there, in some sets lordship, there is no answer, only the questions is there. That is a statement recorded by the another judge lordship, trial judge lordship. That's the problem. We made it gap because of that reason also.
There are two sets of questions.
Yes, lordship. In the first
Yeah.
time, when we concluded the argument in the trial court also, that time the 313 statement reply was not there. It was blank. And thereafter also again 313 taken by the trial judge, then thereafter again argument heard.
This is in that place where we have said that there is that subpara 1 and 2. After that, you write the learned counsel for the petitioner submitted that there are two sets of
Statement and
statement of the accused
recorded under 313.
recorded in section 313 CRPC. And therefore, this the inadvertent error in the paperwork is crept up. Then at this juncture, same thing. Okay.
Obliged, lordship.
Yellow lines. Item takes.
Okay.
Item 3, supplementary list for delivery of order.
More you want to add?
Lordship.
Anything more you wanted to add after this orders were given to you?
But you have taken out to judgment lordship that Y.S. Mannan.
Okay, well. This is one or two judgments.
I'm not done to it, lordship. Here,
Okay, we'll take it after some time. We'll take it after some time then, okay.
No.
So the rest of the file is elephant's tooth,
lordship.
okay. Okay, we'll have the call after some time. This item 1. Yes,
Earlier rejected this, but this on the order is at page 41.
page
41.
41. Was the LCR available then?
Yes.
Scan copies were available.
Yes.
Okay. We'll list it on Friday along with that other record.
My district clerk is that my lord, as my lord, after considering that DNA sample was collected, my lord. And now out of 8 witnesses, already 6 witnesses are over. Till now, that report has not come. It, my lord, may kindly please to peruse. I have even next, my lord, the order at page 46, my lord, page 46.
46.
Yes, the order was passed on 1/3/2023. And as per my client's submission, my lord, the sample was collected on 10 March 2023. Behind the bar and the conducting advocate, he has approached at that time that whether it has been received. The same reply is that it has not been received. So according to my client submission, my lord, it was collected on 10th of March 2023, but it's not yet received. The statement of PW1, that is the PW to informant and 164 goes against me. And those records are with me, but my lord has made specific observations while rejecting the order on last occasion. That is why I have not annexed those specifics.
So we'll take that
Yeah.
earlier records, both sides are represented. Ms. S.G. Barwal and counsel for the petitioner submits that the scanned copy of the trial court records were called for in connection with the previous bail application. After the last read, how many witnesses were examined?
Last period, out of 6 witnesses were there.
Out of 8,
6 witnesses. I
6
think.
were examined. Okay.
For one witness, actually 1 year went by because she was not appearing. Last the court issued warrant, then only she appeared and one examined. 2 were left behind. Out of this, one is the investigating officer and one is an independent. But the main issue is with regard to the report. The report method. The report is not available. That is the because it was collected long back 10 March. Because I have the evidence.
Okay, it is submitted that out of 10 listed witnesses, 8 have been examined.
6 are examined. Out of
6,
8,
6 are examined. Next para. Accordingly, list on Friday. Friday will be
Second of.
2nd February 2023, along with the record of BA 123 of 2023. Okay.
what's the list name?
Yes, item 2.
I think 25 by.
Yes.
We started then back, I think, something like that. I just refresh your logic. Because sometime in 15.5 your logic.
15.5, yes. Oh, okay, this decoding business, all right. Yes,
The facts are very simple. Order is of 27/1/23 at page 14. The matter was for admission and the lawsuit of the matter. The applicant counsel will appear. And then we got. That happened on 27/1/23. Order is at page 14.
yes.
The court order. Matter stands adjourned today. As Mr. B.K. Mahajan, learned counsel for the petitioner, is attired in jeans pant. Therefore, the court has to call for the police personnel to deport him outside the High Court campus. If this order be brought to the notice of the Honorable Secretary, Honorable Chief Justice, as well as to the learned Solicitor General, the matter be also brought to the notice of the Bar Council of Assam. That is the. Twenty-th January 23, he had a cataract operation. And he was asked to come on 27 for a checkup, which he did. And from there, he came straight to your Lordship's court and appeared. The reason for the deporting is, as your Lordship has said, he is attired in jean pants. It's a dress code violation which prompted your Lordship to pass this order. In fact, your Lordship, we have stated that
Yes,
just immediately, this was pointed out, he regretted and he expressed his regret. There was, and he said that it will not be repeated. So that, and there was no sort of any other reaction. That's the whole that he was sick. And disorder. Basically, as I see, two questions are arising. One is, what is the dress code for the Guwahati High Court? Lawyers. To get an audience before this learned judges of this. The second question is, assuming that there was some departure and non-compliance,
for which the current council expressed his regret immediately. There was no other turmoil in court, if I may put it that way. And this order followed. And the security person, it is virtually an arrest. He was arrested and taken out. And not only from the courtroom, but from the High Court campus. And the question is, assuming there is a violation of the press code, what is the order that can come from the learned judge before whom the lawyer is appearing in this court? It's a general question. And what orders can be passed by a learned judge, assuming that there is a non-compliance with the requirements of the dress code specified by this court? These are the two issues which we learn. The first is the crucial thing. Both are crucial, but first is first. Now, the Advocates Act below, Section 34, confers a power on the High Court. If your lordships kindly have a look at that section.
Okay, sir.
The Bar Council of India.
We don't have the same book. We have universals. We don't have this Bharat. That is Bharat publication.
Same thing. Section 34 is the power mirror which Advocates Act confers on the High Court. The High Court may make rules laying down the conditions subject to which an advocate shall be permitted to practice in the High Court and the courts subordinate thereto. The High Court shall make rules for fixing and regulating the taxation or otherwise of the fees we are not really concerned with. So this is the power below which is conferred on the High Court. And below, Section 49 of the same Act confers power on the Bar Council. General power of the Bar Council of India to make rules. The Bar Council of India may make rules for discharging its functions under the Act, and in particular, such rules may prescribe. None may not because double Z. Because it started, by Act of 73, which affects from 31/1/74.
Yes.
The form of dresses or robes to be worn by advocates having regard to the climatic conditions appearing before any court or tribunal. So this is the power, of the Bar Council of India. To prescribe the form of dresses or robes to be worn by advocates having regard to the climatic conditions appearing before any court or tribunal. This power was exercised by the Bar Council of India which is below the chapter 4. Form of dresses or robes to be worn by advocates. Framed under section 49(1)(z).
Yes.
This chapter has been substituted below with effect from 9th March 2003. I have this that. Good. Framed by Bar Council of India.
Bar Council of India rules.
Four of the.
Yes. Yes.
Has been substituted. Advocates appearing in the Supreme Court, High Courts, subordinate courts, tribunals, or authority shall wear the following as part of their dress, which shall be sober and dignified. So first is that a black buttoned up coat, subscribe, Ashkan, black ceremony, white pants with advocate's gowns. That is for the courts. Black, open breast, white shirt, white collar, stiff or soft, and white and with advocate's gown. Coat, shirt, which will be also, and with band, and with advocate's gown. In either case, this is important, in either case, wear long trousers, white, strip, or gray. Dhoti, excluding jeans. This rule below excludes the wearing of jeans. Provided for we have then for the right? So there is the exclusion of jeans in this rule. Part of. Neither case, long trouser, white, black, striped or gray, dhoti, excluding jeans. So Bar Council rules generally provided for all courts that it should exclude jeans. Now, your lordships, now turn to the Guwahati High Court has exercised its powers under section 34. Start after. Waiting for you.
Oh, acha. Okay. We'll resume it to then. If you have some other work, you can come back, Mr. Manan. If you have some other work, you can come back after some time. We'll take it up.
Now, may I just this high court's rule. Yeah, high court rules.
Yes. Yes, I have it. Yes.
Then it is mirror page 270.
Yes.
Right. Or conferred by section 34(1). All other or in it by law and in supersession of all previous orders. The Guwahati High Court of hereby frames the following rules, laying down the conditions subject to which an advocate shall be permitted to practice in this court, in this High Court, and courts subordinate thereto. These rules shall be named as the Guwahati High Court Conditions of Practice of Advocates Rules 2010. Two 16 at page 274. That is the rule. Appearing before the court shall wear the following dress. A black buttoned up coat, a front, or sherwani. Barristers or advocates gown and bands. B black open collar coat, white shirt, white collar, super soft, with barristers gown and bands. Then, Lady advocates. From the Kalachar onwards, it has been happy. So, the jeans, dresses, you also have seen black open, colorful, white shirt, white collar, C4 top, with registers, gowns and bag. Significantly, the stipulation which regards to the exclusion of jeans has been the council rules, almost the same thing so far as A and B are concerned. Almost identical. In either case, wear long trousers, white, black, striped or gray, excluding jeans. So that part, Milord, that is deleted or not adopted by the High Court. And then the rules which came subsequent to the Bar Council. This was in Milord 11/3/2010. At page 270, the lordship gets detailed at the bottom. So we come to this position, because the Bar Council rules was in 2002. 9th March 2002. And this comes on 11/3/2010. So subsequent to the general rules framed by the Bar Council of India. Section 49 WG. So the net effect is, as far as this High Court is concerned, it has prescribed the dress code for advocates who can appear with their dress. And significantly, as far as that Bar Council rule is concerned, almost virtually the entire thing is there, except that exclusion of jeans. Therefore, in my respectful submission, the law as it stands today, whether we like it or not, this court has not chosen to prescribe what the Bar Council of India prescribed, namely an exclusion of the jeans. And this being the specific rule, which is the rule for the, in exercise of this statutory power under 34. As far as the High Court is concerned, it will be applicable. So a lawyer coming in jeans under this rule is entitled to appear, and the court, in my humble and respectful submission, thank all the security person to take him out of the gallows. personally speaking, I'm not very happy arguing it. I'm being honest. But considering the set of facts here and the consequences that the advocate had to face, I am forced to bring it to your lordship's kind notice that the High Court itself has framed the rule, not adopting what is prescribed under the Bar Council of India rules, not excluding the teams. There may be reasons for that. It's a High Court of, not only of Assam, but of the entire northeastern states at that time, and now also at least 4 states which are under its jurisdiction. And in those areas, the teams may be considered to be a daily routine affair. But whatever the reasons is, the fact remains that even though the Bar Council rule excluded, which was known to the High Court chose some spread of it. Therefore, what is prescribed is what we find there, without the exclusion of genes. Therefore, the short submission is, so far as this High Court is concerned, as far as the dress is concerned, the genes is not excluded. And therefore, the advocate is entitled to come and practice and appear before a lordship, wearing a suit. first part of the argument, therefore, in view of the statutory rule which the Elected has seen and which this Honorable High Court has prescribed for the advocates, there is no exclusion of genes. Yes. Gening is a sort of material. The gene can be is normally made of that. But gene is not excluded by your virtue. That's the position. Without the consequences, if somebody comes, your lordships can't deny him audience. Ultimately, without it's a question of the advocate appearing before the Honorable High Court and your lordship has the right to hear or not to hear the counsel. The lordships may not hear a counsel if he is not in proper dress as prescribed by the High Court or the Bar Council, in case the High Court does not feel the condition. Therefore, strictly speaking, in law, the lordships have framed a rule which doesn't exclude genes. Therefore, the special rule which has been prescribed by the High Court will obviously govern as far as the appearance before the High Court judges are concerned by the advocates. And the Bar Council rule will not come into operation. That's my first submission. Therefore, this order, which has passed, apparently is unauthorized. We were not singly when we joined the bar, but we saw either a white pen or a black pen or striped.
Barrister stripes. Barrister stripes.
Barrister type, SK Ghosh used to wear, some of the lawyers used to wear. So that was something which was prevalent. And that is admitted both by this, allowed both by Bar Council as well as the High Court.
But there are traditions and practice. There are traditions and practice. In Calcutta,
Without knowing the rules or without going through the rules ever, for the first time, I have seen these rules because of this matter.
in Calcutta High Court Barristers Bar, the non-barristers are not permitted
No,
to
they are not.
have to sit, and they are not even permitted to have any, the members, they also can't have non-barristers sitting in their chair. But in one of the cases, I was a what do you call exception, because the senior lawyer called me in for a cup of coffee, took permission from each and everyone sitting there. That
They
he
are
intended
quite,
to,
sensitive about.
they intend to offer me a coffee. I said that if so much of permission is there, why we have it? We can go downstairs and have it. No, no. This is a privilege. This is the privilege which I am offering you. They'll not refuse, but I have to ask them. And so I was offered a coffee in their, having it sitting in the chair, and they say it's a privilege to have coffee with us sitting in this barrister's table. So that's a unique experience I had. It's a matter of practice.
They are practiced. So here, of course, as I was saying, we never had the occasion to look into the dress code prescribed by either Bar Council or the High Court. And we always had either a white pen or a black pen. And right, if you can afford, it was also very good, costlier. And we, normally in winter you wait. So that is how it went. But, my lord, it is better that the clarity is there. And that's why the rules are framed. And if Bar Council has framed a rule in 2002, excluding gyms, and this High Court thinks that it is not needed for this lawyers here to follow that, they have therefore not excluded under their. Therefore, legally speaking, my lord, the lawyer is entitled to appear before the High Court here. Querying it. Whether we like it or not, that's the conclusion I will draw on the basis of these two sets of rules. And the well-settled principle that if you have a special rules made, which is a special rule for the Guwahati High Court, it will prevail over the general rules. And it's an audience which is given. Who can give that audience? The learned judge. Why will he deny the audience? One of the grounds is that you are not in proper dress. You will not be heard. As I was saying, my first experience of a dress code came soon after I became a lawyer in September 1967. When I went to Delhi, I thought I'll have a look at the courtroom. So I knew Mr. Now late Gopalakrishnan. So he took me around the courtrooms. And court number 1 was presided by Chief Justice Hidayat. So one matter was called, the learned lawyer stood up and Chief Justice smiles and tells him, we don't see you. Next item, he went to the court master. I was thinking, what has happened? And that advocate also was for a minute, for a second, he was kind of, then some colleagues said you were not in, your gown is not there. Oh, he said, I'm sorry, he ran away from the court. When I went out, I asked Mr. Gopalakrishnan, why did you not see him? I thought he speaks. Why is he saying that we don't see you? No, it's not seeing. You see, he is being denied the audience because he is not in proper dress. So that was my first experience of a dress. So that is how it is. But it is a matter of a lawyer appearing before the learned judge. If you are not in proper dress, you will be denied audience because there is no other sanction. What happens if you are not in dress? The lordship will not find any consequence or what a judge will do if your lawyer is not coming in proper dress, either under the Bar Council rules or under your lordship's High Court rules. But the Supreme Court has explained this is inside the courtroom. The learned judge decides what is right or what is wrong within the court, within his courtroom. That is the whole idea. And when you are given an audience, you are in compliance with this particular requirement, apart from others. Legal qualification part. But if you are not in dress, what can the learned judge do? There is nothing, no other provision which authorizes that this is what you can do. But it is your inherent power that you are not going to give him the audience. You will not hear him. You will not see him. And Justice Hidayat Lassa. Chief Justice. And it's a Bombay court, where the page, copy the lordship. One, it's not the precedent, but this is how that is Hidayatullah dealt with his mind. And we don't see it. Sometimes it may not be that smooth. So here is a case from a review bench of Bombay High Court. Advocate for this petitioner is not in proper dress. Send over to state July petition. That means you are denying him the audience. He can't argue before you if you are not in proper dress. I was saying that this is a between the learned judge and the advocate who is appearing before him. And why is this necessary, the power in the High Court? It is because the court proceedings are controlled by the learned judges. Bar Council of India can't determine that. That is what we find, in a judgment which in 2001, case FCC 650 is related to Milord, a rule of Kerala High Court concerning content, which provided that you must purge the content. We are not on that aspect because it is not with regard to content. But there are observations which I would like to place before Lordship to show that what happens inside the courtroom, it is the learned judge's prerogative.
I have it, I have it. I have it.
Look, this is Robin C. Shah.
Yes,
If your Lordship kindly turn to the internal page at the top, page 8, paragraph 16.
yes.
Rule 11 is that concern, relevant rule, the purging of the contempt is necessary in order to enable you to. Rule 11 of the rule is not a provision intended for the disciplinary committee of the Bar Council of the state or the Bar Council of India. It is a matter entirely concerning the dignity and orderly functioning of the courts. The right of the advocate to practice envelops a lot of acts to be performed by him in discharge of his professional duties. Apart from appearing in the courts, he can be consulted by his clients, he can give his legal opinion whenever sought for, he can draft instruments, pleadings, affidavits, or any other documents. He can participate in any conference involving legal discussions. Rule 11 has nothing to do with all the acts done by an advocate during his practice, except his performance inside the court. In this case, that advocate concerned, he was convicted of contempt, but he kept on appearing before other courts. So that is how the matter came up. Ultimately, the Supreme Court also didn't accept his apology because it was not held to be genuine. But arising out of that, this case has come around. And this is what is important. Inside the court, conduct in court, this is important. Conduct in court is a matter concerning the court. And hence, the Bar Council cannot claim that what should happen inside the court would, and what should happen inside the court. Court could also be regulated. I'm just conduct.
You can ask him to read.
Concerning the court.
Mr. Goswami, you can ask him to read, no issue with that.
Conduct in court is a matter concerning the court. And hence the Bar Council cannot claim that what should happen inside the court could also be regulated by the Bar Council in exercise of its disciplinary powers. So what happens inside the Bar Council is not competent. The right to practice, no doubt, is the genus on which the right to appear and conduct cases in the court may be expressive. But the right to appear and conduct cases in the court cannot be divested. Is a matter on which the court must have the major supervisory power. Hence, the court cannot be divested of the control or supervision of the court merely because it may involve the right of an advocate. When the rules stipulate, then it goes into the matter of the. Okay. So what is found over the thing? In the theory of dispensation of justice, according to law in the operations of the court, proceedings inside the courts are always expected to be held in a dignified and orderly manner. The very sight of an advocate who was found guilty of contempt of court on the previous hour, standing in the court and arguing a case or cross-examining the witness on the same day, unaffected by the contemptuous behavior he heard at the court, would erode the dignity of the court and even corrode the majesty of the court. This is what I am emphasizing. This necessitates vesting of power with the High Court to formulate rules for regulating the proceedings inside the court, including the conduct of advocates during such proceedings. That power should not be confused with the right to practice law. While the Bar Council can exercise control over the latter, the High Court should be in control of the former. So inside the courtroom, the learned judges are the primary authorities. What happens here, Bar Council can't decide. It is your lordships who will control that proceeding, how it should go about. This next paragraph 18 is important because they are approving an Allahabad High Court judgment in the context of a despot. In the above context, it is useful to quote the following observations made by a division bench of the Allahabad High Court in Swaraj versus Swans. The High Court, this now is quoted, the High Court has a power to regulate the appearance of advocates in courts. The right to practice and the right to appear in courts are not synonymous. An advocate may carry on chamber practice or even practice in courts in various other ways. For example, drafting and filing of pleading, Okalatnama for performing those acts. For that purpose, his physical appearance in courts may not at all be necessary. For the purpose of regulating his appearance, this is the important. For the purpose of regulating his appearance in courts, the High Court should be the appropriate authority to make rules, and on a proper construction of Section 34 of the Advocates Act, it must be inferred that the High Court has the power to make rules for regulating the appearance of advocates and proceedings inside the courts. Obviously, the High Court is the only appropriate authority to be entrusted with this responsibility. Now, paragraph 9. In our view, the legal position has been correctly delineated in the above statements made by the Allahabad High Court. The context for making those statements was that an advocate questioned the powers of the High Court in making dress regulations for the advocates while appearing in court. So it was in that context, the Allahabad High Court went into the matter. Somebody questioned me, what right have you got to prescribe a dress code for us? So this is what the court has held, and the Supreme Court has approved and said that the courtroom proceeding is inside, and it is the learned judges who will decide what is to be done, what is not to be done. And this is where, the audience. That means if your lordships find that I am not in proper dress, your lordships will not hear me. That's the sanction for the dress code. If you keep on repeating, you will not be heard. No lawyer can afford to have that situation. That is the sanction ultimately. Why you will not? Why you will maintain the dress code? Even from the side of the advocate. If you do everything but you don't follow the dress code, the judge will say, sorry, we don't see you. You are not in proper dress. That's the sanction. And that's a very important sanction. So far as the lawyer is concerned, he can't afford to repeat that. If he does it, it is penalty. No client will come and engage a lawyer who cannot appear in court. So that is the sanction. And that is the enormous power that the court will have to enforce the dress. It has serious consequences for the lawyer if you violate it. He doesn't get the audience before your lordship. He can't appear. Who can afford to do that as a lawyer? Professional. Apart from the guard that will come to him. But he can't be seen in court arguing. Not in. Therefore, my lord, the sanction and the consequence of violation is not spelled out, but it follows from the inherent power of the High Court that it is the guardian of the proceedings which take place within the court's courtroom. And that is what Bar Council has no jurisdiction. It is the advocate and the learned judge. If he thinks that he is not in proper dress, he will say, I'm sorry. You will not be heard. You don't have to say that, as I have said. To say that, loud, just smile. Solve the problem. Because the division bench in Bombay is saying he is not in dress adjourned to so and so, the implication is obvious. So this is how the courts will function. And the advocates must conform to that. Whether it is, therefore, as I was saying, that I am not happy arguing that first point. Because I would not like to come and argue before your lordship with a G. Although, if you are given the gown also, I mean, you generally don't see what is, whether it's a jean or a black belt. And I saw the American gown which our friend Sitaj Das was presented with by somebody. It is open here. That gown was, I found, there is a tip, and he will just take it here, right up to here. It's all closed. So whether it's a jean or a other pant, no judge can detect. You see the gown only. That's the American style. He was telling me that this is, I got it from America. See, that is how things are. But normally it's open now. Therefore, we are not in proper trousers.
You have seen the movie, my cousin Vinny.
Yes,
You have seen that?
Most interesting. And have your lordship seen the fate of a lady judge in that Nevada?
Yes.
Huh?
Yeah, I've heard of it in the news.
I read in the papers about the assault on the judge by the accused from the witness box. He went and then from this, he just dived. That has come, somebody showed me from the YouTuber. And it was a devastating blow, which made her fall down, and he was grabbing and first the security people of the within the courtroom or near about, they came, they could not take him out. Ultimately, the real police people came immediately, and he just took him out, and that lady, she is brought out from the ground, he was shaken, obviously.
Obviously. But we had our own, we have our own stories to tell. Justice Hidayatullah, he
That's what I was about to say that.
he caught a assailant.
That fellow also did the same thing from the courtroom, courtmaster's table, he was with that knife. And
This
he
is
was
Hidayatullah.
smart enough to hold him.
Uh-huh.
Unfortunately, I think it was Justice Grover who had a little scratch.
I don't remember that, but yes, this bit of Justice Hidayatullah was,
But that, and he appeared, that's criminal offense. If somebody does that, that's a criminal offense. Therefore, the case was lodged against him, and Chief Justice Hidayatullah went and appeared as a witness from the witness box. There was a suggestion that it will be done in commission. He said, no, I want to go and stand as a witness. Lord Denning was thrown an egg in his face in courtroom. Not
even
by
in Supreme Court, 4 women hurled saddles on the honorable judge. In the Supreme Court also,
Yes,
4 ladies, they hurled a shoe on the judge.
yes, yes,
It's about 2004,
yes.
5, something like that.
But that is not by a lawyer.
No,
It is by people who are coming either
Yes,
as
yes.
an accused or a visitor or something of that kind.
yes,
But it is a criminal offense there. Apart from contempt, it is criminal. You can't throw a egg or a shoe on a person. So that is the situation. Here you call the security or the people who are around you immediately, and then they can't control the others will come immediately. So that is how it is managed. The courtrooms can be vulnerable. I'm seeing that thing. I was telling somebody that, you see, it is not a very cozy job. You must remember serious. So you have to be an alert person. But that lady, I really faced when she was brought out after that fellow was taken out of the court. Yeah. Terrible. But that is something done by a non-lawyer. I hope lawyers will not, at least not so far I have heard of it. And that people took down to that level. But we have this kind of cases after contempt. That's why the rule of purging was there in the Kerala High Court rules. And Supreme Court said, yes, they have to apologize, and apology has to be a genuine apology. It just can't just pay fine and then go to the next court and do again the same thing. That's not that. So fortunately, my lord, we are celebrating 75 years. We haven't had that kind of situations where a court had to call security and take some people out of the court. Fortunately, that is so far it's a grace of the people, the dignitaries, and as well as the great advocates. So this is the entire concept that proceedings in court is controlled by the learned judges. Appearance before that court, if you are not in compliance, you are denied that on this precious right of audience. And without audience, what does a lawyer do? Who will come to him? To bring. Therefore, that is the sanction. You don't find any penalty or any power conferred on the High Court to take some step in case this is violated. Nothing. Why? Because this is the essence of the whole system. And why is it necessary that it should be controlled by the High Court? You mentioned and explained. It is to maintain the dignity of the court. Therefore, my lord, whether the lordship accept the first or the second argument, it is, so far as this case is concerned, this is immaterial. Your lordship's order denies him the audience on that. That is all that should have done. Yes. Because kindly see the situation. Assuming that High Court rule is not there and Bar Council rule is there and he is not complying with that rule by coming into jeans. Let me assume for a moment. What can be done by the learned judge? You can say that you are not in rest. I don't see you. I adjourn. You are not getting audience from me. That's all. And that is what is intended. If suppose he retorts back, just in this case, what is your right to prescribe a dress code? Or he refuses to go out and argues with the learned judge and creates a ruckus. I hope it will never happen. It has not happened in this case at least. He was very civil and polite. He immediately apologized and said it will not be done. And I am happy to tell your lordship that he has not done that. He is maintaining his word. He is not coming with cheese. Therefore, this part of the order, namely directing the security people to come to decode him, not only from the courtroom, but from the High Court premises. This is something absolutely unheard of. You can't do it. With all respect and humility, I am saying this. This is not contemplated under the law. Assuming that he is wearing jean was a violation of the rule of the High Court or of the Bar Council, it doesn't matter. High Court rule doesn't contain it, but let's be assumed that for the sake of dignity, he was violating, and you are entitled even to preserve that and say, okay, but in the context of the earlier rule and the latter rule deliberately leaving out that, that is not possible to argue that way. But I am only saying that if there is a breach at all, it was a breach of the Bar Council rule wearing a team. That is all that your lordship mentions. Now, what can thereafter follow? If the advocate concerned behaves the way my client has behaved before your lordship, one situation, it may have been a worse situation if that was questioned to your lordship and he insisted on still appearing before your lordship and asked your lordship to hear him, that would have been a different situation. That situation never occurred. He immediately apologized and regretted, and he said it will not be done. After that, to call the security with a direction to take him out, that is arresting. Under CRPC, that will be arrest. You are impeding the movement. You are touching the body. Don't touch the body, you are just impeding, guiding. It will be arrest. Under what law that can be done? With great respect, I was considering that to myself. It is a very serious issue, as far as the advocates are concerned. Assuming that there is a violation of the dress code, would the security fellow be brought in and told that you decode this fellow outside the campus? Outside the courtroom, you don't have that jurisdiction as a judge. It is within the courtroom's proceedings that things are happening. You are the only authority, as per the Supreme Court, to regulate them. And violation of a dress code is not spelled out. The sanction is, he doesn't get the audience. That's the sanction. Question of, in this set of situation, where there is no other argument or debate by the advocate, it is absolutely unthinkable that security will come, arrest him, take him out, not only from the courtroom, but from the High Court premises. With the utmost respect, I have great respect for your lordship, and in all humility, I will request your lordships to ponder and think it over. That this was not a right step to take. You could have ensured by only saying, as the Bombay High Court has said, adjourn. You are not in proper dress. Next day, if he does that, steps may be different. But not security fellow, unless there is a ruckus inside the court by an advocate, which I am yet to see anywhere. We are fortunate in 75 years, we don't have an incident of that type. And I'm sure it will never happen again.
There's one more citation you have given.
Well, that is a well-settled principle. Maybe I will just. That is that. Para 34, 134. President Welfare Association versus Union Territory. That in this site you Para 134 below. That's the end. Internal page 39. Below.
Yes.
Turn over the page.
Yes.
There's a different part in the next page, which is 40. Last 4 or 5 lines of the paragraph. It is a settled law that in case of a conflict between a special provision and a general provision, A special provision prevails over the general provision, and the general provision applies only to such cases which are not covered by the special provision. This is following that 61. That is quite well said. So, review is the jurisdiction. So looked at from either view, first argument is that there is no rule as such, therefore wearing jeans is not something which can break that kind of. Assuming it is not, I am not right there for any reason. And we take a stand that there is a violation of the dress code by wearing jeans. Then also below, in the context which appeared on that day before a lordship, and his submission and request and his statement that it will not be repeated and he is sorry for it. That should have been, his denial of audience on that day was quite appropriate. But beyond that, because kindly see the position, your lordships have been a judge, an advocate. Because directing the security to come arrest an advocate out of the courtroom and not only out of the courtroom, high court premises, and the publicity that was given. Kindly see the position of an advocate. How could that be done? It can't be done. The advocate may be guilty of not complying with dress code. What can the learned judge before whom he is appearing to? Has the law given him a power that you can call a security police and then throw him out of the high court premises? With the greatest respect, no. That power has not been given to the judge. So, one has to be reasonable in exercise of powers. That is the ultimate requirement, a fair dispensation of justice. He may have done a mistake. He is apologizing. You don't use a sword to cut a lily. And what kind of a situation like this? Kindly think of it. He's taken out and he can't stay not only in the room but in the entire high court premises. Where is that power? Sure, your right to freedom is a fundamental right. Your right to movement, a fundamental right. You can't, unless some law prescribes that right, you can't. And the So, in my most humble and respectful submission, Sir Lordship, the power of review is a power which is given under the law. And great judges have not shrunk from their duty at times to say that, yes, I should not have done this. This is the reason. So don't, look, it's not as if we are coming in confrontation, no. I have accepted, already the punishment has been given. I could not have got a worse publicity than what I have got. But all that is apart. It is a precedent, it's a court of record under the Constitution, the High Court. This remains as a part of the record. And this is a continuing stigma attached to the advocate that he was decourted from the High Court premises. Must be a fraud or something. It can't be an arbitrary power, but with greatest respect. Sometimes we make mistakes. We err is human. That's what we have learned from the early days. And judges are not immune from that. Sometimes it happens. I can understand you. All of a sudden, something has happened. But it's a matter of introspection also. And also seeing how valid it was. That I'm sure your lordship's openness of mind will always be there to view the entire situation and then. So in any view of the matter, whether your lordship accepts the first or the second, the position ultimately is that denial of audition is the only rule if you don't have any accompanying violence or any kind of patrimony to the judge. And that is something which was happening on that day. There was no acrimony, there was nothing except the regret he has expressed before our lordship. And he said that it will not be done again. And it has not been done till now. And it will continue, I am sure about it. And whether, beloved, your lordships should look into the rules is a matter for your lordships to consider. But kindly see, it is not there. And you could not have invoked the power that to arrest and throw out a man from the High Court campus because of the gene. Because you have, the High Court has framed a rule that doesn't exclude the genes. Right or wrong, that's the position. And your lordships feel that it was a commission which should be rectified, it's for your lordships to do it in future by amending the law. As it stands, below with greatest of respect, below to your lordship, and in all humility I am submitting, that your lordship's order would not have been done under the law. And I beseech your lordship to have a relook and then decide, because justice of the case, I feel, demands that. Deeply.
Ernest P.K. Goswami, Senior Counsel, assisted by Mr. A.K. Barwa, Counsel for the applicant, and Mr. K. Bushra, learned APP for the state. Argument is concluded or reserved. Yes, Mr. Manan, your matter.
Yeah, coming.
Yes. Yes, Mr. Manan.
Actually, yeah, just the two judgments that I have given, basically on that, these two judgments. These two judgments are on the fact
that here, your lordship, what has happened in this matter? We have challenged uh, the prolonged incarceration of the person who is behind the bars for about 2 years or more. Now this is more than 2 years. The other two co-accused have been granted bail on the ground that there is a violation of Article 21 of the Constitution of India by the court. So this only point is here is that if there is a violation of Article 21 with regard to the other co-accused, and this period is actually the same for all the three accused because all the three were arrested on the same day. In this case, your lordship, therefore, he is also entitled to be granted the bail on the ground of prolonged incarceration because that is the court has held violation of Article 20. My learned friend has submitted about a few judgments, which I have got a copy of them. That type of judgment, your lordship, other matters, some court has held, yes, there is prolonged incarceration, somewhere it has been held, no, it's not prolonged incarceration. I'm not going into that because there, I also can give another 10 judgments where it has been given. I'm not coming into that. My question here is that I have submitted these two judgments. These are on the fact that, your lordship, with regard to the point that the coordinates bench judgment, with regard to in such matters, the other bench, earlier judgment should prevail by the court. Those are two judgments I have given. One is a little bit earlier 2020 judgment. That is in the case of S. Kasi, as a state through the Inspector of Police. Lordship has got that. Here, your lordship, I refer to para 3 paragraph, para 31, 32 and 33. 31, 32 and 33. And the other, your lordship, is Mary Pushpa. This is a recent judgment. This was delivered on 3rd of January, 2024. This is here, your lordship, I refer to para 1, 17, 18 and 19. Here the only
Para 1, 17 and
1, 17, 18 and 19. Basically, this is with regard to the part of your lordship, coordinate bench judgment should be followed. That's it. Because here we are not on the merit of the case, whether this person has been caught, other is not. If it is a parity matter, where your lordship, what happens if somebody has been caught with the drugs, somebody else was not there, then that parity comes, he has been given, just because he is a co-accused, he is not entitled to the benefit of it. Here it's a case where the violation of Article 21 was held to be in the case of the other two persons, and the same person, the third person, the same should happen. That much.
in response to the submissions of Mr. Y.S. Mallan, counsel for the petitioner, in replies concluded, Ms.
M. Decca.
M.
Decca.
Decca, and counsel for the respondent is present.
I have given the copies to them.
Lordship, there is one correction, Lordship. Two witnesses have been examined, not one, Lordship. The two witnesses have been examined.
Two witnesses.
Earlier it was one, now it is two.
Okay. Pass the orders.
Much of.
If I'm unable to upload it by tomorrow morning, I'll give a date. Otherwise, if I can upload it tomorrow morning, then it's ends the matter.
Much.
Item 4.
It is not on the record, madam. Can it be after tomorrow? Day after tomorrow, just for 1 or 2 months.
On first, okay. List of 1 to 2024, along with affidavit filed by the petitioner. Petitioners. Mr. K. Bushel and AP is present. The case diary be retained till then. The case diary is with us.
Yes.
Case diary between the
What does tell us? What is the affidavit about?
The petitioner along with the bailers went to the police station.
Oh, for that reason. Okay, okay. Okay. Thank you.